Solar Michelin. Solar Michelin. I feel now. Ready to
Yes.
If I may, my lord, may I please make a mention on an unlisted item? Criminal Appeal 35 of 2024. My lord, the reason for this is that the petitioner is currently in custody, so he has certain medical ailments which requires treatment.
Criminal matters you listed before the other courtroom.
My lord,
Courtroom number 2.
a similar case was disposed by a lordship.
Okay.
Similar FIR.
Okay.
That is the
Yes.
reason why I approached this.
Yes, allowed.
DPO.
This is tomorrow.
Promotion, item 1.
Lordship, this is a matter pertaining to promotion in supersession of the petitioners who are senior to the private respondents in service. Lord, the petitioners were appointed to the post of AG2 in the year 2012 as per Annexure 2, as per Annexure 1 and 2 at page 21 and 22, Your Lordship.
Yes.
And the services were confirmed on completion of the probation period. And the seniority list was published on 27 February 2024. And thereafter, Your Lordship, there was a notification dated 13 March 2024 for which the post of AG2. Your Lordship, at this stage, may I state that initially AG2 was the entry grade, but now AG2 is a promotion post for the post of AG1. In the meantime, AG2 has been redesignated as AG1. Now, the petitioners who were originally appointed to the post of AG2, they are now going to be promoted to the post of AG2 again.
Okay, so
But the thing is-
AG2 is more senior to AG
AG2 is a promotion post
from
for
AG1.
AG1. Yes. As on today, after amendment of the rules.
Where are the rules?
And
Yes, where's the rule, amendment of the rule?
Lordship, before coming to the rules, may I take a Lordship to page 28? This is the impugn notification. At page 28.
Yes.
It is stated that in pursuance to the resolution number 6 of the Board of Directors meeting held on 23/7/2024, and in the interest of the bank and public services, the following assistant grade 1 employees are hereby promoted to the post of assistant grade 2 in the level 8 of pay matrix of the bank, plus all other allowances as admissible from time to time. And the name of the private respondents are at serial number 6, 10, 11, 12, and 14. 6, 10, 11, 12, and 14. And the petitioners, both of them are placed at, in the panel list for 2 years. Miriam Laltlan Moi and Zoe Sangswadi. They're in the panel list. And the petitioners had submitted their appeal to the Chief Executive Officer as per Annex 5, Annex 7 at page 29, and the translated copy is at page 30. And in response to the appeal submitted by the petitioners, the respondent number 2 had issued a letter rejecting the appeal of the petitioners. At page 33, Your Lordship will see
Okay, they had appealed on the grounds that they were more senior
yes, they're senior to
to
the
the
private respondents.
private
Yes.
respondents. Then what is the reason given in the
And
appeal?
the reason for not entertaining the appeal of the petitioners is that number 1 at page 33, number 1, the promotion result was carefully prepared by the selection committee meeting and was thereafter approved by the board meeting. 2, as per the staff service amendment rules 2024, number 23/7, the yardstick for promotion of Channel B from AG1 to AG2 is based on the marks obtained under various heads such as performance, maximum 45 marks, personal interview, maximum 35 marks, and seniority, maximum 20 marks. The result thereof depends upon the aggregate of marks obtained from the said 3 yardsticks. All employees of a bank are having APAR, that is, Annual Performance Assessment Report, right from the time they join service, irrespective of whether their services have been confirmed or not. Employees in AG1 who are facing personal interview are all having APAR for 5 years or more. 4, the promotion process of a bank regarding Channel B promotion is unlike the promotion process under government, where service seniority is given top priority. In fact, service seniority carries the lowest marks amongst the 3 yardsticks for promotion as mentioned before. Due to this, some seniors were superseded by the juniors even in the early rounds of promotion. In the present process of promotion, in other grades, not only in respect of AG1 to AG2, promotions were made not necessarily in accordance with the seniority list. Though the employee's performance or APAR marks are kept confidential, you may be informed that all the candidates for promotion from AG1 to AG2 have the required benchmark for promotion as required under Staff Service Amendment Rules 2024, number 19(1)(c). The above being the situation, it is hoped and expected that you may continue to serve with the same zeal and devotion for the bank, and though you are now in a panel list for promotion, you'll surely get the desired promotion in due time, for which I convey my best wishes for the same.
So here this explains seniority is not one of the criteria.
Yes, seniority, it is, there are 2 channels.
Not giving much importance to seniority here.
That is true, according to them.
Ah,
According to them.
yes. Then-
But Here,
What is that?
the rules relating to promotion,
Okay,
2024.
I think we should have those rules also as a part of your, petition. You Xerox the first page showing what rule it is, and then you incorporate the relevant part. You see? Oh, yes.
May I take a lordship to page 25? Rules relating to promotion. And the relevant provision is at page 27, Channel B, seniority, performance, etc. But before coming to this, let me take a lordship to Rule 23. In case 22.1, in case of any two employees securing equal marks, the final selection shall be made on the basis of interested seniority. 2, an employee who has been selected for promotion but refused to the promotion or posting. These are not very relevant. 3, an employee on promotion shall be liable to be transferred. 4, if for extreme administrative reasons beyond the control of the management, promotee is not released from duty, not very relevant. Officer in MMG 4 and below shall be required for the purpose of promotion to complete at least 2 years of his service in the bank at a branch other than branches located at his hometown. An employee who feels aggrieved with the promotion decision may appeal within the period of 3 months to the managing director or chief executive officer, who shall in return place the matter for review to the board of directors, whose decision shall be final. And under 7, distribution of marks in examination or interview. Written test carries 100 marks, and performance below average 0, average 1 to 11 marks, good 12 to 23 marks, very good 24 to 34 marks, outstanding 35 to 45. Seniority, 1 mark for every completed year of service up to a limit of 20 marks. Completed year of service shall be calculated only from the feeder post and 6-month wise. Serving less than 6 months will not be counted for marking. Marks secured by candidates will be converted. And here, Channel A is merit cum seniority. The next page, Channel B, where we are, it is seniority, performance, etc. The weightage to performance, seniority, and interview will be in the ratio of 45, 20, 35. So here, this is the general guideline in respect of promotion under Channel B. And all the posts under the AG1 to be promoted to AG2 are for, under Channel B. There is no provision for promotion under Channel A. So the petitioners had submitted their candidature and under this Channel B. And on the basis of the interview, performance, and seniority, those are the 3 things which were assessed. The respondent bank had taken into consideration all the marks obtained by the candidates. And on the basis of the aggregate marks, the seniority, the merit list was determined. In this connection, though the petitioners were senior to the private respondents, the performance and the aggregate of marks obtained by them being shown to be lesser than those of the juniors who were included as private respondents. They have not been selected for promotion. So accordingly, the petitioners had expressed their grievances. And Your Lordship, a similar case was earlier decided by this Honorable Court,
Okay.
as shown here at page 35, Annexure 9. In this, may I take a
Since
Lordship to
2007.
2007 years. Para 5 of the judgment at page 39. May I read the Lordship? The factual position noticed above not being not in dispute, the only contention adumbrated by the bank in the affidavit in opposition is that while giving promotion to the assistant grade 1, the list of senior incumbents in assistant grade 2 has been prepared on the basis of the marks scored by them, and out of the select list thus prepared, 15 incumbents have been promoted to assistant grade 1 strictly on the basis of their merit. According to the said respondents, the promotion order impugned is in terms of Rule 19 of the Staff Service Amendment Rules 1995, which provides that promotion to all grades in different categories shall be subject to availability of vacancy in accordance with the rules of promotion framed by the board or executive committee from time to time and on the basis of qualification, efficiency, and performance of the employees concerned. It is further contended that even though seniority channel in Appendix 3 of the Staff Service Amendment Rules 1995 is the only source of promotion, it has been clearly mentioned in the said appendix that the promotion is to be by way of selection on the basis of the marks obtained on 1. Seniority, 2. Performance, and 3. Interview. Seniority being one of the 3 criteria for promotion provided in the said rules. It is also contended that selection is the outcome of the sum total of the 3 criteria, and therefore the question of promoting the selected candidates on the basis of inter-se seniority cannot be allowed. Similar is the case with the petitioners in the instant case, Your Lordship. Bearing in mind this perception, I'm reading para 6, Your Lordship. Bearing in mind this perception of the bank respondent set out above, the true meaning of seniority cum merit principle need to be correctly understood. The Apex Court had occasions to decide similar issue and noted that while the principle of seniority cum merit lays greater emphasis on seniority, merit cum seniority laid greater emphasis on merit and ability, and seniority plays less significant role. In BB Savaya versus Adanki Babu, reported in 1998, 6 SCC, page 720, which has been followed in Hari Govind Yadav versus Rewa Siddhi Gramin Bank and others. In 2006, 6 SCC 145, the Supreme Court observed in para 18, it is quoted, we thus arrive at the conclusion that the criterion of seniority cum merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. For assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required and also prescribe the mode of assessment of merit of the employee who is eligible for consideration for promotion. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service record and interview, and prescribing the minimum marks which would entitle a person to be promoted on the basis of seniority cum merit. It would be seen that in Hari Govind Yadav Supra, the Supreme Court further observed that the minimum necessary merit can only be assessed by the bank through interviews. Once the senior incumbents are found to have the minimum necessary merit, selection thereafter for promotion with reference to comparative marks is contrary to the rule of seniority cum merit. So, Lordship, it has been clearly spelled out here that after the candidates who are in the zone of concentration, who had appeared for the personal interview, are assessed, and if they are found to have acquired the minimum requirement, the benchmark, then the question of comparing the relative merit on the basis of performance and other things is no longer required. Though the rule will be there, but the sum total after making the assessment, if a senior is eligible and if a senior is having the minimum required benchmark, then he cannot be superseded. This is the law that has been laid down by the PEX Court and which has also been held to be applicable in a case in connection with the Sri Lalchan Puya versus the
Anyways,
PEX.
I think
the
you've made your
cooperative
point. We have made your point. We'll issue notice first.
Lordship. And since
Because
though-
the rules says otherwise, but you have produced the judgments. So we'll see whether the respondents will also have some other judgments. So we'll have to look into that.
even earlier the rules were there, Lordship. So
okay.
the rules were not struck down, but the manner in which assessment is made, that has been given proper direction.
Okay.
So
Yes.
similar thing has been done. Even thereafter, Lordship, the notification which was made on 10 November 2007, Lordship, this
These
is
judgments are also for bank employees.
yes
isn't it? Not
from
state. Okay.
from the bank employees, from Apex Bank itself.
Yes, yes, okay. We'll issue notice first. Let's see. Right, Mr. But one thing I've observed in your writ petition, you have not enclosed the rules. You can say the rules are very bulky, that's one thing. But the relevant portion,
The relevant portion, Your Lordship,
have you Xeroxed it or something?
uh,
The one which you have read, Channel B, is it here?
it is Appendix 3, yes, Your Lordship,
me see.
at page 112.
Page 112.
112. Channel B, seniority, performance, etc.
No, it's
Promotion
here
from
in,
assistant.
you have this here, but in your writ petition. Okay, I have a feeling that you should Xerox the first page to tell us what it is.
All right.
And then the relevant portion should also be here as a part of your writ petition instead of us having to search for the rules.
That will be more convenient, Your Lordship. That will be more convenient.
Yes, because
I
if
have
we
not
were
done
to
it.
have a look at it beforehand,
Yes, yes.
then we'll have to search for the rules. So the first page of the rules, what is it that you have annexed, that should be there along with the relevant portion which has to be looked into, isn't it?
Yes.
Otherwise, for us again to search, find out whether there are such rules available or not, it's
That's true.
difficult and it's not been incorporated in your writ petition.
Lordship, the impugned notification was issued on 23rd July 2024. And though they have joined the respective posts, we have a prayer for staying the operation of this impugned notification. Lordship, if the court finds that it is in the interest of justice.
We'll issue notice first, then we'll see. Yes, heard Mr. Sila Ramzawa, learned senior counsel for the petitioner, assisted by Mr. Mr. So-and-so, learned counsel. The new para, the instant writ petition filed under Article 226 of the Constitution of India is assailing the legality and the validity of the impugned notification dated 23/07/2024, along with the letter dated 12/08/2024, which is a letter rejecting the appeal made by the petitioners against the impugned notification dated 23/07/2024. the learned senior counsel for the petitioner submits that the petitioners were appointed to the post of AG2 within brackets, subsequently redesignated as AG1 on the amendment of the, this will be on the amendment of these rules, isn't it?
This is,
Subsequently re-designated as AG1. When was this?
that is in 2024.
As per this?
Yes, as per this 2024 rules.
As per the Mizoram Cooperative Apex, as per the Staff Service within brackets Amendment Rules 2024. Yes. Now, before that, you write this sentence, okay, the petitioners were appointed in the year 2012 to the post of AG2, then within brackets, subsequently redesignated as AG1 in the amendment of the Staff Service Amendment Rules 2024. In the meantime, the respondents number 3, 4, 5, 6, and 7 were subsequently appointed to the same post in the years 2016 to 2018
And
respectively.
2018.
And 2018 respectively. Thereafter, the respondents number 1 and 2 took steps for filling up of 14 posts of AG2 under the seniority channel, that is channel B, white notification dated 13/03/2024. Good stop. The petitioner, along with the private respondents, were the eligible candidates amongst others. And had faced personal interview conducted by the respondents number 1 and 2. The respondents number 3 to 7 were selected and for promotion to the post of AG2 along with other senior incumbents, while the petitioners who were senior to the said respondents number 3-7 were placed in the empanel list only. Full stop. The petitioners, being aggrieved, had submitted their appeal against the said promotion of respondents number 3 to 7 and they're being placed in the empaneled list under Rule 2 within brackets 6 of SSR 2024. SSR is
Staff Service
Staff Service
Amendment Rules.
Amendment Rules 2024. The appeal was, however, rejected by the impugned letter dated 12/08/2024. Aggrieved, the petitioners have approached this court by way of filing the instant writ petition. Issue notice of motion to the respondents. Okay, Mr. C. Lalpa Zola. Learned Counsel accepts notice on behalf of the
Respondent 1 and 2.
respondents number 1 and 2.
I will file on my power today.
No, Mr. Silva appears on behalf of respondent, okay, instead of accepts notice, appears on behalf of respondents number 1 and 2 and submits that he will be filing his form within the course of the day.
My lord, I can accept notice. I can.
Accordingly, he accepts notice on behalf of respondents number 1 and 2. Noted to issue formal notice to respondents number 1 and 2. Notice be issued to the private respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Meanwhile, requisite extra copies of the writ petition to be duly furnished to the learned, to respondents number 1 and 2. The learned counsel for respondents number 1 and 2. Yes, list after 3 weeks.
Your Lordship, so far as the interim prayer for staying the operation,
Interim order, the prayer made by the learned senior counsel for staying of the impugned operation of the impugned notification dated 23/07/2024 is to be considered in the next date.
Obliged.
For admission, item 2.
May I please, Your Lordship? At the outset, my lord, I'd like to submit that the case is about the passing over of family pension of my late father. And at this stage, we have received a letter dated 18 July 2024, Lordship. The respondent number 3 have already taken initiative. So the case may be disposed of with,
Okay.
by
Okay, very good. Heard Mr. LLB Aknungan Namte, learned counsel for the petitioner, along with Mrs. Iram Sangpoy, learned CGC, appearing for the respondents. The learned counsel for the petitioner submits that they have received a letter dated 18 July 2024 from the respondents
number 3.
number 3, wherein certain documents have been called for, which indicates that the respondents are taking steps for payment of the pension, is it?
Yes.
And entitled to the petitioner. The learned counsel for the petitioner thus submits that the instant writ petition may be withdrawn since the respondents have taken positive steps for payment of the pension due to him. Ms. Zaram Sangpui, learned CGC, submits that if the documents called for are available, they will be able to release the pension of the petitioner as prayed for.
My lord, liberty may be given if any, in the event
Okay.
that any
In view of
unexpected
the above,
events may.
the instant writ petition stands disposed of on the prayer made by the learned counsel for the petitioner for the withdrawal of the said writ petition. However, the petitioner is given the liberty to file afresh if so advised by the petitioner. Yes,
Obliged, my lord.
Item
if so
3.
advised, okay? No petitioner.
My lord, if I may be given 2 weeks' time to file rejoinder affidavit.
Rejoinder,
Yes, my lord.
Miss
The Ropare.
Lalropari, learned counsel for the petitioner, submits that she may be given 2 weeks' time to file her rejoinder affidavit to the counter affidavit filed by the respondents. In view of the above, list after 2 weeks.
Yes, much obliged.
Item 4.
Your Lordship, in this matter, I am newly representing respondent number 5. So may I seek for time to file counter affidavit for the private respondent?
Yes, yes. Miss
Rudal Watfeli.
Rutlal Rolfali, learned counsel for the petitioner, is present, along with Mr. Bilal Ram Enga, learned counsel for respondents number,
Number 5, my lord.
respondent number 5, and Miss
Lalui on behalf of the
Lalui.
AAG.
learned government advocate for the
Mali. Your Lordship,
state respondent number 1. The learned counsel for respondent number 5 has prayed for time to file his counter affidavit. In view of the above, list after 2 weeks.
2 weeks, my lord. Much obliged.
Item 5.
my lord, in this case, I will be representing respondent number 5. And if I may be granted 2 weeks time to file my affidavit.
Okay, who is Miss
Laropari.
Lalopari? Learned counsel for Lalopari, learned counsel for respondent number 5. Oh, okay, Dusty is complete and you're represented. Okay,
Yes,
okay,
my lord.
then Miss
Bilaram Nemi.
Bila Ramegi, learned counsel for the petitioner, is present and submits that they have served notice upon respondent number 5 and affidavit to the effect has been filed. Ms. Lalopari, learned counsel submits that she will be representing respondent number 5 and has already filed her part.
Yes, my lord.
The learned counsel has also prayed for time to file their counter affidavit. Ms. So-and-so, learned government advocate for respondents number
1 to 4, Your Lordship.
1 to 4, has also prayed for time to file the counter
1
affidavit.
to 3.
In
1
view
to
of
3, Your Lordship.
1 to 3. In view of the above, list after 3 weeks.
Item 6.
My lord, I will be appearing for the respondent number 1 and 2, and I will be able to file my power within 1 week.
Yes, Lalopari, you can, where is she? You are for the petitioner, isn't it? Ms. Lalopari, learned counsel for the petitioner, is present, along with Ms.
Vanal Swami,
Valal Swami, learned counsel, who submits that she will be appearing on behalf of respondents number
1 and 2.
1 and 2
Respondents.
and will be filing her part shortly. In view of the above, list after 2 weeks.
My lord, 4 weeks may be granted as we have not yet received a parawise comment from our client, from the respondent.
Who are the, okay, it's a CADC, okay, yes, for list after 4 weeks for the learned counsel for the respondents to file their counter affidavit.
For order. Item 7.
Yes, bail application. You had mentioned that it's coming here for the 3rd time, is it?
Yes, my lord.
What happened? So we had rejected your bail application previously. Where's that?
On the grounds of medical.
Pardon?
On the grounds of medical.
Okay. On medical grounds, you had prayed for release on bail, which was rejected by this court.
Yes, my
Is it-
lord.
Where's that order?
Order is in page. Order is in page 72, my lord.
72. Yes. So where's your operated part? Why did we reject the bail?
It is in para 11, my lord.
10. Read from 10.
This court on perusal of the letter dated 18/1/2024 issued by Dr. Lalmankimi, MD, Consultant Department of Medicine, Civil Hospital, Aizawl, finds that the concerned doctor has stated that the applicant will be staying in the hospital till she is completely cured for her pyelonephritis. However, the doctor has stated that she will be requiring regular checkup. Thus, considering the nature of the letter issued by the concerned doctor, dated 18/1/2024, this court finds that there is no immediate need for release of the applicant on bail since she is now at present undergoing proper treatment at Civil Hospital Aizawl. The letter dated 18/1/2024 does not mention that the accused applicant is not medically fit to be remanded back to Central Jail. However, considering the fact that once discharged, the applicant will be requiring regular monitoring, this court find it fit to direct the superintendent Central Jail to ensure that once the applicant is discharged from Civil Hospital on being completely cared for her pyelonephritis, he should ensure the adequate facilities are given so as to enable the applicant to have regular checkup if and when advised by the doctor, by the concerned doctor. Accordingly, this court finds that no sufficient grounds have been met for release of the applicant on bail at this stage.
This is the last order.
Yes,
Now,
my
what
lord.
are the fresh grounds that you have prayed for? Has she been released or is she still in the hospital?
She has been released from the hospital.
Okay, and she's in Central Jail going for regular checkups?
Yeah, yes, but it cannot be improved.
Okay, let's see what fresh documents do you have? Because here the order says once she's discharged from the hospital, the jail superintendent should ensure that she's given the proper facilities is given so that she can have, the applicant can go for regular checkups. Okay, so now now let's see, what grounds have you come before this court?
My grounds is
Fresh grounds?
the seizing officer deposed that he recovered the seized article from the physical possession of the applicant.
Okay, so evidence has been recorded now in the court.
Yes, it is based on the evidence. It is in page 52, my lord.
So now it's no longer medical grounds, it is something else. Yes, page 52.
52, my lord.
Yes. How many prosecution witnesses are there altogether?
Out of 8 prosecutions, 6 witnesses are the prosecution witness and 2 witnesses are the independent witness.
Okay, so how many witnesses have been examined?
All complete.
Okay, so all the witnesses have been examined, prosecution witnesses, is it?
Yes, my.
So what is the stage now?
313.
313, okay.
Then it is in para 15 or page 52. It is a fact that the essay was recovered from the physical possession of Eden Moye. But if I may go to page 53, my lord. Para 1, page 53, para 1,
53 or 63?
53.
53, para 1.
Yes, cross-examination para 1. It is a fact that when I raised the PO, I saw the 2 female accused persons which were detained by the excess personnel and the alleged involved backs are also present at that time. This is the Caesar witness, independent witnesses. This means that before the Caesar witness arrived, they already detained the accused persons in the back, the alleged back, which allegedly contain the methamphetamine. Then it is in page 55, my lord. This is the cross-examination of Caesar witness number 2, prosecution witness number 3. It is in para number 2. It is a fact that when I raised the PO, the LS bag was not carried by the accused, Eden Moye, but it was placed beside the accused person. I do not know the color of the LS bag. Thus, the seizing officer said that the essay was recovered from the possession of the applicant, but the Caesar witnesses adduced that the LS bag was already being recovered, and it is already detained by the excess police personnel. This means that whatever stated by the by the seizing officer was not supported by the independent witnesses, and this clearly indicates that the independent witnesses are hostile witnesses, which override the embargo of Section 37 of the NDMPS Act, 1985. And I'm relying, in this matter, I'm relying here. Bill application number 97 of 2024, my lord. It is in para 21, page 7, para 21. And may I read down, my lord? Under the facts and circumstances of this case as discussed herein above, and in light of the observation made by the apex court, this court is of the considered opinion that in the instant case also, the independent Caesar witnesses have not supported the prosecution case, and the petitioner is detained behind the bars since the date of his arrest, and he seems to have no role in the delay in culmination of the trial. Hence, the long incarceration of the above named petitioner outweighed the embargo of Section 37 of the NDMPS Act 1985, and the petitioner is therefore entitled to get bail on the grounds of prolonged incarceration. In this precedent, is stated that if the independent witnesses did not support the prosecution witnesses, then the accused get bail on the grounds of the.
How long has she been in judicial custody?
She is in 1 year, 10 months and 7 days. It is in second para of my grounds. And the applicant, since the date of arrest, she has been detained behind the bars for a long period, which is 1 year, 10 months and 7 days. And this prolonged incarceration would override the embargo of Section 37 of the NDMPS Act. And my third grounds is on the essay, the officer in charge put COMEX facsimile seal of COMEX Mizoram instead of putting his respective seal. It is a violation of Section 55, my lord. If I may read out Section 55.
What?
Of NDMPS Act.
How?
Police protectors of Article 6 and delivery. An officer in charge of a police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles 6 under this act within the local area of that police station, and which may be delivered to him, and shall allow any officer who may accompany such article to the police station, or who may be deputed for the purpose to fix his seal to such article, or to take samples of and from them, and all samples so taken shall be sealed with the seal of the officer in charge of the police station. On the essay is supposed to be put the officer in charge seal, but in my case they are putting the COMEX seal. This also override the embargo of Section 37 of the NDMPS Act. And my ground number 4 is also violation of Section 55. The sample was drawn on 15/10/2022 before the magistrate Aizol, and it had been sent on 17/10/2022. 17/10/2022. It can be seen in the page 62, my lord, of my petition.
So in the judgments which you have given, in one, the accused was in jail for 3 years and 8 months. And the trial, the witnesses are yet to be examined. Okay, this is the dated 26/6/2024. Okay. Now, in the other judgments which you have given me, here the accused was in for, I think, 1 year something, 1 year, 7 months, and witnesses to be, only 4 witnesses have been examined, and there were quite a number of remaining witnesses, 7 witnesses were yet to be examined. Okay. And the seized article were, I think, cough syrups or something like that here. Cough syrup bottles. Okay. Now, since you have brought these judgments, I'm just saying the case. Okay. We'll keep note of that. 2 judgments you have cited where the accused were released on bail during trial, but in these 2 cases, witnesses are yet to be examined. In one, he was in jail for 3 years, 8 months, the other 1 year, 7 months. And the nature of the seized articles were also in one cough syrup, the other more serious, I think, methamphetamine tablets. Okay. And in these, the prosecution witnesses are yet to be examined. Okay. So your submission is that all the prosecution witnesses have been examined?
Yes, my lord.
313 examination is done or yet to
No,
be done?
Yet to be done.
Okay. And when is the next court date fixed? Any idea?
Last court date is 23rd and it was adjourned.
Adjourned. Yes. So
Might be
your
yes, might be
situation
yes.
is not similar to the judgments which were produced by you. Okay. Yes. Anything else?
Then, my lord,
Then you're taking me to the evidence adduced by the prosecution witnesses, but you're pointing out bits and pieces of sentences.
this is the KSIO cross-examination.
Cross-examination.
It is in para 19. It is, may I read out, my lord?
Yes, page.
Page 62. It is affected sample was drawn on 15/10/22 and was sent to FSL on 17/10/2022 since 15/10/22 was Saturday and 16/10/2022 was Sunday. But if I may go to para 22, it is a fact that I have no evidence to indicate that the sample of the essay which was drawn on 15/10/2022 before the JMFC was kept safe in ANS custody before the sample was received by the FSL. During the period of 15/10/2022 to 17/10/2022, the sample which was drawn before the magistrate was not kept safe in the custody of the ANS, and because of that, the sample was examined more than the weight of the sample drawn before the magistrate. Then,
Anyways,
my lord, it is in page page 41 of my application. Then these are the sample drawn before the magistrate. 3 samples are drawn out from the essay marked as S1 weighing 5 grams each. END, ANS, MT 1A, 1B, and R1. 5 gram each was drawn from each item. And if I may go to page 26 of my petition. This is the report of the FSL.
yes.
END, ANS, MT 1A of a polythene packet containing red tablet weighing about 7.4 grams marked here as chemical
One is 5 grams, one is 7.4. That's their
7.4
point, huh? Okay, got it, got it.
ENDANSMT 1A.
Yes.
And in the sample drawn, it was 5 grams. And when the FSL raising the sample, that was sent by the excise.
But
and
there are
they raising
judgments
and it
where the
becomes-
measuring the vessels could not be accurate also, isn't it?
Yeah, it was not correct.
So,
Then it was more than the weight of the sample drawn. And this
so
overriding-
let the person explain this, isn't it? Now, yes, anything else?
Then
You see, I'll tell you frankly, Jacinta, I am not very inclined to grant bail at this stage by looking and studying the evidence, which I feel at the time when your arguments are heard by the concerned court, whether the accused should be acquitted of the charge or not, considering the fact that now all the prosecution witnesses have been examined, the stage is only left to the stage of 313 examination. Okay. So we will pass an order. Yes, anyways, what are you going to say in this matter?
My lord, first of all, regarding the hostile witness, my lord, we have no hostile witness.
There's no hostility.
Yes, they are not hostile, my lord. They have simply stated the facts. And regarding the seal, my lord, no prejudice has been caused because we have seen that when it was sent to the FSL, it was intact. Everything was intact, and no prejudice has been caused to the petitioner. And regarding this violation of Section 55, that the samples were sent, my lord, at page 37 of the petition, my lord, it was kept in safe custody. It was kept in the safe custody in go down number 1 on 14/10/2022. So nothing,
Yes.
there's no
So,
grounds. for that.
no
My lord-
glaring
My lord,
evidence, yes.
the six articles are gray and black and gray color bags, wherein it contained wherein it likely contained the methamphetamine, but that bag was not kept safe was not deposited in the Malkhana.
Yes. Okay, so these points which you have raised, I think you raised them before the trial court at the time when, after what time for hearing of arguments, whether the accused is acquitted, because it is not for this court to really delve into all the evidence and see whether he is innocent or guilty of the offense. Okay. And we'll only look into the fact that she has been in custody now for 1+ year, 1+ maybe 7 months, you say, in custody.
10 months.
However, at this stage, it is seen that prosecution witnesses over. Okay, prosecution witnesses, and the stage is at the stage of examination of the accused under 313 CRPC. Okay, thereafter, the next step will be for hearing of the arguments. So it is at its final stage now of completion of the trial. In view of the above, we will pass an order that the whole process, since it is at its final stage, should be an attempt should be made to complete or dispose of the case within maybe, what would be more practical, 1 month, 2 months?
1 month.
Within a period of 1 month. Okay, so we will pass an order that since this is the stage, okay, the learned trial court will make an attempt to dispose of the matter within 1 month. Then isn't it? Because now prosecution witnesses, evidence is all over. It's at its final stage. Got it? Yes. And she's been in custody for 1 year something. 1 year, how many months?
10 months, 7
10 months.
days.
1 year,
10 months, 7 days.
7 days. Okay, only that much. Okay. While the cases which you produced, in one, methamphetamine, and he was in custody for more than 3 years. Okay, because of that, those were one of the grounds taken into consideration. Now, in the other one, it's 1 year, 7 months, but the seized articles were cough syrups. In your case, it's again methamphetamine, and quite a huge amount. Okay, so we'll see. We'll pass that order that an attempt should be made to dispose of the case within 1 month.
Yes, madam.
I'll pass the full order later.
Item 8.
Your Lordship, an additional affidavit has been filed by the applicants. So if time may be given to file an objection.
It's a continuation application. What were the additional affidavits filed?
My lord, your
Oh,
lordship
concerning
heard
the,
this matter on the previous occasion, and to support the statements made in the application, I have been granted time to bring on record some materials.
okay,
So,
materials
The
showing
main
that.
grounds, the main grounds of delay is that before they approached me, they have approached two other lawyers, and the case was passed over and over after one another.
So
and
what material did you
The
produce?
previous two counsels had declared by way of affidavit that the manner in which they have handed over the case.
Yes, so this doesn't need any written objection. We can hear the matter, isn't it? We can hear it today, or you want another date? We'll dispose it of today.
If another date may be given, Your Lordship, because I didn't really prepare for the matter because I was planning to.
No written objection for those not required. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, along with Mr.
Jonathan.
Jonathan
Learned
Lilwin
Kruanga.
Kruanga, learned counsel for respondent number 1
One
and
and
2,
two.
and Mr. Yes, Ram Murmur, learned counsel for. Yes? Oh, okay. Yes, okay, along with Mr. K. Thangrem Sa, learned counsel for respondents number 3 and 4. The learned counsel for the respondent number the learned counsel for the learned counsels for the respondents have prayed for adjournment of the matter since they are not prepared for the matter to be heard today. In view of the above, list in the next week.
My lord, if it may be taken up after 2 weeks, I have some inconvenience in the
Okay.
following 2 weeks.
In view of the above, as prayed for by the learned counsel for the applicant, list after 2 weeks.
Item 9.
Yes. What is this IA about?
Lordship, this IA is about amendment of the IA of 71 of 2024, my lord. Amendment of the cost title, and as per the order of last court date order, we have submitted the IA with the corrected cost title, lordship.
What? You want to bring on on record certain documents?
Yes,
is
my
it?
lord. Yes, my lord.
And you have asked to make an amendment to your application.
Yes,
for
my lord.
to bring on record certain documents. So now you have made the amendment.
Yes, my
and you have filed the fresh application under Order 41, Rule 27.
Yes,
is it?
lordship.
To bring on record certain documents.
Yes,
So we'll issue notice. Isn't it? What sort of documents?
Lordship, like very important documents which has not been produced in the lower court, lordship.
Why were they not
Lordship,
produced?
because that our client, he's a very simple man, so he did not have much knowledge about this court proceedings, lordship.
Okay, we'll issue notice. Heard Miss
Rosie Mandom Sangi, lordship.
Rosie Manlom Sangi, learned counsel for the applicant / you're the appellant? slash appellant.
My lord, we are the defendant. In the main, in the main case, RFA, lordship, we are the
Lordship, they are applicant in the
in the
IA.
IA only. We are the
Okay, only in the IA.
yes,
Okay.
lordship.
Okay, heard Ms. The learned counsel for the applicant who,
I'm also
who submits that the instant application filed under Order 41 Rule 27 of the Court of Civil Procedure Code, Code of Civil Procedure, okay, is to bring on record certain documents which were supplied to the applicant through RTI. She further submits that the said documents were not previously produced before the learned trial court, since the applicant. Now here it appears that he has passed away.
Yes, my lord. He has passed away on 6/4/2024, lordship.
So you wait. Since the appellant, who is now Mr. T. Vanlalwata, now represented by his, now substituted by the, now, okay, wait, change the order, okay? Since the applicant, who is now representing her husband, Mr. T. Vanlalwata, within brackets, date, found out that her deceased husband, Mr. T. Vanlalwata, had not submitted the instant documents, which are in fact necessary for the proper adjudication of the case. Full stop. Okay. Issue notice to the respondents, Mr. C. Zoram Chana, learned counsel for respondent number
Responding number 1.
Number 1.
1,
And 2, 3, and 4 are state pro forma respondent.
and Ms. Caroline K. Lalungoifui, learned counsel for the state respondents,
2, 3, 4.
except 2 to 4, is it?
4.
Accepts notice on behalf of the respondents. No need to issue any formal notice. Requisite copies of the said application is to be duly furnished to the learned counsels for the respondents. Yes,
My lord, I'm also the amicus for the respondent.
now you are for,
I am for the respondent, the Valarwata. And then eventually, I was appointed as the amicus, but then the learned counsel, Mr. Joseph, is the neighbor, is the respondent's neighbor. So again, he submitted Vakalatnama and then.
so you were, okay, so you'll not be appearing anymore then, is it? Or you're going to be together? Since now they have a council,
Yes, my lord, that is really up to this honorable court, Your Lordship.
Mrs. Lalngai Sangi Fanai,
Lalngai
learned
Saki.
Lalngai Sake Fanai, learned amicus curiae submits that she was previously appointed by this court to represent the applicant, okay, slash appellant, okay. However, since the applicant has now engaged a counsel to represent her, she would like to withdraw from being appointed as amicus curiae. Okay. Praise the Lord.
My lord,
What?
instead of that,
Okay, okay.
not withdraw,
Okay,
The court need not, something like that.
Okay, no, but are you, this thing, are you meeting the person, having some interaction? Or you want to still, okay,
The
I got your
learned
point.
counsel
No.
Joseph said that we can like assist each other, but however, it's up to this honorable court, Your Lordship.
No, then if you can assist each other, then you, but is it really required? No, to be assisted?
I don't think so, Your Lordship.
Uh, okay, instead of withdraw, has engaged a counsel. In view of the above, this court finds that the services of Langai Saki, learned amicus curiae, may no longer be required. Now, you are appointed in the High Court, is it?
Yes,
Now, this court, however, in appreciation of the services rendered by the learned amicus curiae, find it fit that she may be paid a fee of 5,000?
Yes, ma'am. I think.
5,000 for the service rendered by the learned amicus curiae till the appointment, till the applicant/appellant had appointed counsel to represent her case. Yes. The Mizoram State Legal Service Authority may do the needful. And copy of this order may be duly furnished to the Mizoram State Legal Services Authority. Yes. Then list after
List after 2 weeks.
2
and
weeks.
If we may have a fixed date, my lord. If I may suggest 17/9 for the next quarter.
after 2 weeks on 17/9/2024. Yes.
Deeply obliged, Your Lordship.
Much obliged.
Item 10 to 13.
May it please Your Lordship. The present application is for implement of the present incumbent Deputy Commissioner of Siha District as respondent number 15 in its connected contempt case, madam.
In place of respondent number
Number 11, 13.
13. I heard Miss Bilal Ram Nemi, is it learned counsel for the applicant/petitioner, who submits that on the transfer of the previous respondent number 13, the present incumbent, Shri V.L. Shwaizel Akhiangte, Deputy Commissioner of Siha District, may be pleaded as respondent number 15 in the connected contempt case number 22/2019. Accordingly, this court find it fit to implead the present incumbent, Sri V.L. Shwaizel Akhiangte, as respondent number 15 in the connected contempt case number 22/2019. Accordingly, IA number 138/2024 stands allowed and disposed of. Yes.
And my lord, similar order may be passed for the link cases.
Okay.
However, for item number 13, the newly impleaded may be arrayed as respondent number 14.
This is IA
IA
140.
141. Yes.
Yes. Okay, same order for 139, same order, IA 139, same order?
For 140 also.
No, but the numbering of the incumbents.
Yes,
Will it be the same for
same.
139? Okay.
Yes.
Now for 140, it will be
15, same.
140?
Yes. For 141, it's different, my lord.
Okay, same order. Okay, 11, and then it will be 14, is it? What was the previous order?
14, yes, my lord.
14. Is it instead of 11,
Mm.
it's going to be 14. So now in 141, instead of 11, it will be?
14.
No,
For IA 141, instead of respondent number 11, the newly implemented will be respondent number 14. Item number 13, my lord.
Okay. Yes. Just read out the last order. No, the numbers. No, the number, implemented as respondent number. Yes, that's why you're saying 14. It's 15. So in IA number 138, it will be what?
Respondent
To instead of respondent number 11,
13. Just,
okay, instead of respondent number 13, it's going to be respondent number 15.
yes, my lord.
Okay. So in the others also, except for 141, it will be instead of respondent number
15.
15, it's going to be respondent number
No, my lord.
what?
Instead of respondent number 13, it will be respondent number 15.
15.
Yes, my lord.
Okay. In the others, it is instead of respondent number 11.
Yes, my lord.
Are you sure?
Let me check first.
Check.
For IA 139, similar, my lord. IA 39, instead of respondent number 13, it will be 15. For IA 140,
Same.
same. For IA
141, it will be
11, instead of 11, it will be 14.
So you're
12.
confusing me because you're saying instead of 13, it will be 15.
If I may clarify,
Okay.
my lord.
So then you're saying instead of 11, it will be this, but there's no 11. That's what I'm confused. Instead of 11, it will be,
My lord, this item number 10,
uh,
11 and 12, it will be same order. But in item number 13, that is IA number 141 of 2024, the new incumbent will be respondent number 14 in place of respondent 12.
12. So there's no 11 here, isn't it? So it will be, in the others, it will be 13 to 15. And in this, it will be 12 to 14.
14. Yes, my lord.
Yes. Because I could see from your face that you were not sure. And you were just
Apology, my
making,
lord.
giving me numbers. Okay, you could always look and see. Yes. Now, in the main contempt, okay, in contempt, in the main contempt in 22, 23 and 27, okay, contempt case number 22, 23 and 27, heard Ms. So-and-so, Bila Ramnian, Learned Counsel for the petitioner, on the disposal of, again, the connected IAS. Okay. Issue notice to the newly implemented respondent number 13, Mr. B.L. Shoya, Learned Shoya, Deputy Commissioner so-and-so, to registered post with AD within 3 days, returnable by 3 weeks. Now, in the contempt case number 28/2019, it will be heard so-and-so, then issue notice to the newly implemented respondent number 14. Okay, to registered post with ADC models. Yes.
Deeply obliged.
Item 14.
My lord, this matter is also for implement of the new incumbent. As per the lordship's last order. My lord, in the IA, the new incumbent, that is the new general manager of NF Railway, Sri Arun Kumar Chaudhary, will be replacing the earlier respondent number 9.
Okay.
who was the former general manager,
as respondent number 11.
as respondent number 11.
And
And the new deputy chief engineer,
will be 12
Will
in
be
place
12.
of respondent number
5, will be
Five,
in place number 5. If your lordship will allow, will serve notice.
Heard Mr. Jonathan L. Silo, learned counsel for the petitioner. This is an application filed under Order 1, Rule 10, within brackets 2 CPC, read with Section 151 CPC for the implement of Mr. Arun Kumar Chowdhury, comma, General Manager / Construction, comma, Northeast Frontier Railway, comma, Maligaon, comma, Guwahati, as respondent number 11 on the transfer of the previous respondent number 9. The previous general manager who was arrayed as respondent number 9. Okay. And to implead the present incumbent, Mr. Shri Tikesh Jaswal, comma, Deputy Chief Engineer / Construction / Konpui, within brackets, and Bairobi, close bracket, comma, Northeast Frontier Railway, comma, Tarapur, comma, Silchar, comma, Assam, dash 796070. As respondent number 12 in place of the previous incumbent who was arrayed as respondent number 5. Accordingly, as prayed for, same. Okay, so and so. And IA number 144/2024 stands allowed and disposed of. Then in the main content, heard Mr. So-and-so, learned counsel for the petitioners, on the disposal of IA 144/2024. Notice is to be issued to the newly impleaded incumbents, respondent number
11 and 12.
11 and 12. Okay, respondent number 11, so and so his name, and respondent number 12, so and so his name. Okay, with the address, through registered post with AD, within 3 days, returnable by 3 weeks. List after 3 weeks.
Lordship, I have been requested by Mr. Eskamadi if the matter may be taken up on 9th September. He's appearing for respondent number 5.
3 weeks will be 9 September. No, it will be too short. After 3 weeks, let him come after 3 weeks. Yes, notice is going to be issued.
Respondent number 5. So he is the newly implemented.
Yes, any hearing matter?
Item number 12, can we take up in the afternoon?
12.
Yes.
Why? Why in the afternoon? Can't we do it now then?
Or maybe listed in the next week.
What is the matter about? Is there any urgency?
This is regarding the composition, which was not released, the solicitum and interest, which has been already sanctioned.
We list it in the next week?
Yes,
Or you
my
want
lord.
it? Or it can be heard tomorrow, it's still within this-
Tomorrow I'm having a hearing in arbitrator, 5 cases.
Okay. Heard Ms. Jacinta Zotan Moy, learned counsel for the petitioner, who has prayed that this matter may be listed in the next week. Accordingly, list in the next week. Yes.
Much obliged.